part of this training. Excellent. So as you probably know, if you've signed up, there will be CLE for live attendance of this training, and we'll also be recording it for future use. So we will be referencing CLE codes during the training. Please make sure to write those down, and we will require you to confirm your attendance and provide the evaluation. So just a little bit about NIJC and our team. As you can see up here, I manage the Non-Detained Kids Project at NIJC. We work generally with vulnerable immigrant young people, mostly in Illinois, Indiana, and Wisconsin. We work with kids who have been abused, abandoned, or neglected, who are seeking Special Immigrant Juvenile Status, which we'll talk about today, but we also help them with all forms of immigration relief. And we're part of the National Immigrant Justice Center. So for those who are not familiar, NIJC is a full-service immigration law nonprofit. We serve low-income immigrants, refugees, and asylum seekers nationally. We have offices in Chicago, Indiana, San Diego, and Washington. And what makes us unique is we have years, decades of experience providing direct services, which really informs our policy and our impact litigation projects. And so those three branches work really well together to inform each other, and just makes NIJC an awesome team to advocate for the work of immigrants. A really important piece of NIJC's programming and our capacity and our ability to serve as many folks as we do is our pro bono program. So we will be talking about SIJS, and Berenice Sanchez-Ruiz, our pro bono coordinator for the SIJS project, will be reaching out to you at the end with a case list of cases if you're interested in taking a pro bono case from us. It's not required for the webinar, but we are always interested in folks who are interested in volunteering with us. And we'll start out the program today with a few words from Deepak, who is a great pro bono attorney who has worked with NIJC in the past, and will be able to speak a little bit to what it's like to work specifically on this type of SIJS predicate order case. So if you wouldn't mind, we're going to start out by making sure that everyone can record your attendance so that you can get that CLE credit. Please take a moment to scan this QR code. I believe these slides will also be distributed after the meeting, but we like to get this done right away. So if you wouldn't mind, pull out your phone, scan the attendance, and we'll get you registered to make sure you can get your CLE. All right. Oh, I'm seeing notes that the form is unavailable. All right, we will make sure that this is distributed after the training so that everybody can record their attendance. Apologies for the tech issues. So I want to start out in the interest of time just talking a little bit about NIJC's pro bono programs generally. As you can see, if we can go to the next slide, we've talked a little bit about these branches of our pro bono program. There we go. The direct legal services, the advocacy, and the federal litigation, which all inform each other. And this is made possible by our large network of pro bono attorneys. In the past year, we've worked with an average of about 1,600 pro bono attorneys, which is amazing. Our pro bono programs function because NIJC does extensive screening when we meet with our initial clients. So the way that the path that an immigrant may take to seek pro bono representation through NIJC is that they will contact NIJC because they need an attorney. NIJC will do an extensive screening for whatever type of relief that person may be eligible for. This is especially true in our SIJS cases because we want to make sure that both the child is eligible, that the experience of seeking the SIJS predicate order is feasible and traumatizing in a minimal way to our clients. So as much as possible, we want to make sure that it's sufficient and that it's done in a client-centered way. And then if the case is accepted, we'll sign a retainer with that client and we'll begin to look for a pro bono placement, which is part of why we do these trainings to spread the word about both the form of relief and the need for pro bono attorneys. Once a pro bono attorney agrees to accept a case from NIJC, you will be assigned a technical support attorney. That would be for our SIJS case, either me or Dominique Mejia, who is also going to be giving this presentation today. And we use our templates, our guides, our checklists, and direct contact pretty constantly throughout the life of a case. So you will get support every step of the way, because we want to make this both a good experience for you as a volunteer, for the client, because we want to make sure everyone wants to come back and do more of these cases, because as we know, the need is really great. I do want to take a moment and give a big shout out both to our pro bono teams, Berenice and Dominique, in our SIJS project, but also to Chicago Volunteer Legal Services, because right now, Illinois cases, they co-counsel on all of our cases. They often co-counsel on our trainings as well, but they are the family law experts in this scenario. And so you will not only be paired with an NIJC technical support attorney if there are any questions that are beyond our capacity because they have more to do with family law or guardianship law, you will be in contact with experts who can help you every step of the way. So that's a little bit about our pro bono program and placement. And you don't have to take my word for it. I am going to turn it over to Deepak, who is going to talk a little bit about his experience as a pro bono attorney on SIJS cases.
Thank you, Hillary. I appreciate the introduction. Good morning, everybody. My name is Deepak Tamasker. I'm a staff attorney with McDermott, Will, and Emery in Chicago. I am in the corporate advisory group, so litigating, family law, these are all new concepts to me. So the reason that I think I appreciate being here is because the most recent SIJS case that I worked on was the first from the predicate order perspective. So as you'll learn during the course of the webinar, there are two parts to this obtaining an order in state court, and then the immigration application process. So I had been familiar with the latter part through working on a SIJS case where one of my colleagues had obtained the predicate order. And then this time I was actually on the front end obtaining the predicate order. And as a non-litigator, as someone who did not reside in the county where my client's case transpired, it was a brand new eye-opening experience. And I just want to encourage everybody to take a case, first of all, obviously, and then second of all, be confident that you can handle it because of the step-by-step materials and expert guidance of Hillary and her team, as well as the CVLS team. Every single question I had, every little nitpick here and there, it's like, I don't know what to do. I'm standing in front of a judge for the first time and God knows when. What happens? And then, Hillary and her team, they walk me through every question, every filing, every bit of advice that I needed to obtain. I got from NIJC, and it is just kind of indicative of my experience, the level of guidance and the quality of the template documents that they provide as part of the onboarding process. So if there's anything that you take away from this presentation from my part, I would just say, rely on the expertise of the technical attorneys that will be with you every step of the way, and stick closely to the templates because they work. That's the reason that they're in place, is that there's a history of success. It's not necessarily limited to Cook County. For those of you in Illinois listening, as I said, my case was outside of that jurisdiction, so there's some adaptation that needs to happen. But because of the robustness of the templates, it makes it easy to adapt to your particular circumstances. So you also will need to work closely with support teams, interpreters, if your client is not fluent in English, and just to make sure that the client is comfortable being in front of a judge because it's intimidating, and it's intimidating for the attorney, but far more intimidating for the client, who might be a young child, a teenager, a young adult, as well as their whoever is involved in their proceedings. So just you need to have that level of sensitivity, that level of empathy, and that also stems from working with NIJC, because they have the experience in handling people of all different backgrounds, whether it's from Latin America or otherwise. They're attuned to certain cultural norms and cultural issues that might influence the way that your client wants to proceed, or how much they want to reveal of themselves. So yeah, there's lots of technical parts of it, but there's also the kind of, I don't know, for lack of a better term, the human side of it. Just people from vulnerable situations who are already leery of their immigration status or lack thereof, and they rely on you as the attorney, but then you in turn can rely on NIJC for that type of kind of quote unquote soft guidance. I guess it's not just about where do you put the stamp on this form. It's also how much do you want to reveal about a person's background, given the possibility of the public records access to certain to certain things that you file in open court. So that was one thing that I really learned from Hillary specifically, who critiqued my initial drafts of pleadings, and like, okay, you don't need to put this in here because it's sensitive information, or it's potentially obtainable by the public. So just how to be efficient in your pleadings, and in addition to the mechanics, like this has to go there, this has to go there, make nice with the judge's secretary, think like little things like that, like these practice pointers that you will not be able to find externally. You can't just read it in a book and say, okay, this is how it works. But people who have the experience, who have the kind of savvy to understand nuances, and they have experience in different jurisdictions, they have experience with different ancillary players like guardian ad litem, who themselves have they're a plethora of experience. If your case may involve GAL, I've found in my experience it was great to work with that GAL, because we're all kind of, our client is in my case was the person seeking guardianship of a minor, but it kind of worked as a team between NIJC and CVLS and McDermott and the GAL. So it was a team effort. So just I don't want to delay the proceedings too much longer. So just pay attention to this training, obviously, but then after, refer back to the sample materials, the sample pleadings, the memos, etc. You don't really have to do a whole lot more even as a newcomer than adhere to what has worked. So that is my kind of final bit of advice as a pro bono for NIJC. Just work closely with them. I'm sure they get annoyed because they're human, but they're very professional and rapid in their and detailed in their responses to even the most inane of questions. So please pay close attention today, and then stay in touch with NIJC and Hillary and her team to investigate where you can slot in. And you can slot in just about anywhere. Like I said, it's a two-part process, so maybe you're more comfortable being on the immigration filing side at first, but then you can take a step outside of your comfort zone like I did. And sorry, there's some landscaping happening outside, so I'll wrap it up. So, and if anyone has any questions, please reach out to the NIJC team, and they can direct questions to me, or you can ask them in the chat. But thanks again for letting me be part of this, and hope to work with Hillary and her team soon in a new matter.
Great, thank you so much, Deepak. Okay, so my name is Dominique Mejia, and I'm going to be providing a basic overview of what SIJS is, which is Special Immigrant Juvenile Status. As a quick kind of, we're doing some admin things real quickly. My name is Dominique Mejia. I'm a supervising attorney on the non-detained kids team. I want to ask that everybody that has any questions, that if you could please put them in the Q&A section and not in the chat. It's just easier for us panelists to kind of monitor that section. We have a lot of screens open, and that's the one that we have open right now. So could you please put any questions or concerns or things that you want to bring up there. We have sections after each section that we'll address certain questions, but if something is pressing or about a topic that we're currently discussing, we'll bring it up then. Thank you. And then just a quick reminder, this is a two-part training. So this part today, we're going to do a basic overview of SIJS and then how to get a predicate order in state court. We are tailoring it specifically to Illinois courts, but I think a lot of it is applicable to any state court in the country, or at least kind of guiding you into what the steps could be like. The second part will be once the predicate order has been granted and you are ready to file an I-360, which is the actual application for the Special Immigrant Juvenile Status application. And then if that is granted, then adjustment of status. So that is in the second part of the training, which is the 25th. If you registered for this training, you should have also automatically been registered for the first training. Okay, so just a quick admin little update. And so we'll go ahead and start. And hopefully you guys can all hear me well. All right. So today, we're going to talk about Special Immigrant Juvenile Status. So what is it? It's a form of immigration relief available to immigrant children who've been abused, abandoned, or neglected by one or both parents. It's available to immigrant children who are currently in the United States, and the benefits for them are protection from deportation and a pathway to residency and eventually citizenship. Okay? The big caveat for this form of relief is that the child can never petition for a parent, even for a non-abusive or non-neglectful parent. So a lot of scenarios, it's one parent who's been abusive and neglectful or abandoned, and one parent has been a solid rock there for the child. But unfortunately, even if they become a US citizen, they would not be able to petition for their parent, even if they were the good parent. Okay. So this is a statutory authority. If anybody wants to, look up any definitions, look where this is in the regulations. And mainly it's just for your reference in case you're citing to anything. With federal law, the INA section 101A27J and the INA section 245H. It's also in the TVPRA in section 235. And the regulations are here. We rely a lot actually on USCIS guidance. A lot of new guidance has come out. And so we suggest that you look up some of these sections that we have highlighted here, particularly about adjustment of status for people who have been granted SIJS, and different ways to provide documentation for children who are under this eligibility category. Okay. So going into more specifics of who is eligible. So under the statutory, so the INA section 101, a person, sorry, a question just came in and I'm trying to see if I should answer it now. We'll answer it right after. Thank you. So a person has to be under 21 years of age. They have to be unmarried, physically present in the United States, and a juvenile court has to have found that the child should be under the custody, and we'll talk about what custody means, under a state agency, a department, individual, or entity, and that the child's reunification with one or both parents is not viable due to the abuse, neglect, or abandonment inflicted by that parent, and determined that it would not be in the child's best interest to return to their home country. And the Secretary of Homeland Security should consent to the grant of SIJS. So it's a discretionary issue. Okay. So what is a juvenile court? So a juvenile court is any court with jurisdiction under state law to make judicial determinations about the custody and care of juveniles. So here in Illinois, these are a number of courts that would be able to enter a predicate order. So one of them is the domestic relations / parentage court, guardianship, adoption, juvenile delinquency, and child welfare. Typically, a juvenile court order must be entered before the child turns 18. A 2021 change in Illinois law allows children over 18 but under 21 to seek SIJS findings. And so this change in the law was pivotal to making sure that eligibility for people in Illinois at least would fall into the category of the federal limitation of 21. Prior to that, if they were 18, they were out because of state procedures. Every state is different, although a majority of states are now changing their laws so that if a child is seeking a predicate order or SIJS order, they can apply up till 21. Okay, so what constitutes abuse, abandonment, or neglect? These terms are defined in each state's law. This is the standard the court will apply even if the harm occurred in another country. So a lot of our kids that are eligible for SIJS have suffered abuse, abandonment, or neglect in their home countries, and that parent who inflicted that harm may still be in a home country. But a court in the US can make these findings against that parent and based on abuse that was not in the US as well. Although there are cases as well where the abusive parent or the abuse occurred in the US too. So the abuse, abandonment, or neglect must have been inflicted by a parent. By abuse by other caregivers does not qualify for SIJS. In Illinois, these terms are defined in a special section of state law that is specific to SIJS. And so you don't need to look up the definition separately. We may have, if you were to volunteer with us, we provide templates that have those specific citations as well. Oh, here we go. Here are the Illinois definitions. So if you are seeking a custody or divorce order where you would make these findings, it would be from the Illinois Marriage and Dissolution of Marriage Act. If you're concerning parentage or established paternity, it would be the Illinois Parentage Act. If it's a minor guardianship, so minor guardianship under 21, it would be the Illinois Probate Act. If it's a child welfare proceeding or delinquency case, it would be the Juvenile Court Act. And if it's an adoption case, it would be in the Adoption Act with the citations noted here. Okay, so going into specifics. So abuse as defined in the Illinois Domestic Violence Act is physical abuse, harassment, intimidation of a dependent, interference with personal liberty, or willful deprivation, but does not include reasonable direction of a minor child by a parent or person in loco parentis. So essentially disciplining your child does not necessarily qualify as abuse, but if it's excessive, if it's abusive, essentially, you know, there's a line that was crossed between, you know, wanting to direct your child who's doing something wrong versus being abusive to that child. I will note that for abuse under Illinois law, if a child witnesses abuse between parents, so say a father is being physically abusive to a mother and the child witnesses, under Illinois law, that is also abuse of the child because no child should have to witness that. And that has, studies show that that has major repercussions on the child and their development. And so in Illinois law, that also qualifies as abuse, even if the child was never physically harmed by that parent. Abandonment includes, but is not limited to, the failure of a parent to maintain a reasonable degree of interest, concern, or responsibility for the welfare of the minor, or when one or both of the minor's parents are deceased or cannot be reasonably located. I will note for those that are outside of Illinois, this is very Illinois specific. Some states do not qualify death as abandonment, but Illinois we do. This is one of those key differences between our states. In Illinois, we have had parents who were not abusive, who were never abusive, who were never neglectful, who never abandoned, but they passed away. And on those grounds, we were able to get a predicate order for these kids so that they are eligible for SIJS. So just making note of that. And neglect. Neglect is one of those that is more detailed, more specific. So it includes not receiving the proper or necessary support, education as required by law, or medical or other remedial care recognized under state law or care necessary for their well-being, including adequate food, clothing, and shelter, or who was abandoned by his or her parents or parents. Sorry, I think I said it was very narrow. It's actually very broad. So essentially, if a parent has abandoned a child, they've also neglected that child, because if they have not provided any financial means to support that child, have not provided emotional support or check-ins with that child, that is also being neglectful of that child. So if any of you are assessing a case, be mindful of that, so these can be, it can be one or more of these categories, so abuse, abandonment, or neglect, and it can be all three. In the IMDM, which is the Illinois Marriage and Dissolution, caretaking functions also include managing nutrition, hygiene, education, discipline, medical, and social and emotional needs. Okay, so we have a few samples here of who is impacted or who may be eligible for SIJS. So I'll run through these very quickly. For this one, we have Carlos, named age 8, and he's from Honduras. He came to the US with his mother after his father was murdered when he was only 3 years old. He has no one left to care for him in Honduras because his mom is here in the US and his father is deceased. And because Illinois defines abandonment to include when one or both parents is deceased, Carlos was able to secure a predicate order and apply for SIJS, protecting him from deportation. So here's one example. And then we also have Jenny, age 16, from Guatemala. Her father was an alcoholic who physically abused her mother. And when she was 13, her mother fled the abuse and came to the United States, leaving Jenny with her grandmother. Jenny's father saw her occasionally, but was often drunk and never provided for her. When Jenny's grandmother became too sick to care for her, Jenny came to the US to reunite with her mother. Jenny's mother was able to file a petition for sole custody and get an order with SIJS finding that Jenny could not be reunified with her father due to his neglect. So if this was an in-person training, I would, ask a raise of hands to see if anybody thought that we could find another ground for SIJS eligibility. But I'll just, give the answer right now. I would also consider abuse, right? So it doesn't say whether or not he ever physically abused Jenny, the minor, but it does says he physically abused the mother. And so if that happened in the presence of Jenny, that would also be abuse to Jenny as well. So it would be abuse and neglect. Of course, this is Illinois specific, so I would encourage you to look at your state laws, to definitions under your state. All right. So we like to be very, to cater to different types of learners, and including myself. And so I'm very much a visual learner. And so for today's training, we're going to be talking about obtaining a juvenile court order. But the gaining SIJS, or getting what we say kind of like the full benefits of SIJS, is a 3-step process. So the first step is getting a predicate order, or getting a juvenile court order, which is step 1. So that's what we're going to be going over today, particularly specifically in Hillary's section, which will be coming next. The second step is filing that order with USCIS along with a petition, which is the form I-360. And then if that is approved and they have been granted special immigrant juvenile status, once a visa is available to the child, they could then adjust status under form I-45, okay, which is where they would get the green card. Okay, so we're going to be starting on step 1. Another visual slide. So the first steps is to obtain an SIJS predicate order, which is that court order. And then filing the I-360 before the child turns 21. So in some state courts, you have to get a special type of order before they turn 18 or before they're 21, but the actual petition to USCIS only needs to be filed before they turn 21. So what does that mean? If the child turns, today is the 11th, if the child turns 21 today, it should have arrived yesterday. It cannot have arrived today because the child is already 21. So just making note of that. If approved, the client then may receive deferred action and be eligible to seek an employment authorization or a work permit. That has now been automatic, the grant of deferred action, I should say, with the grant of Special Immigrant Juvenile Status. And then we'll probably go into what a deferred action is in a separate slide. And then if approved, they are then in line to get a visa to then adjust status. Currently, it's a 5-year wait from when they submitted their I-360 for when they can then adjust status. And if approved, they then can become a lawful permanent resident or a green card holder. Okay, here's a slide about deferred action. So deferred action for special immigrant juveniles. So some of you may know deferred action as being DACA. But DACA is a form of deferred action. Deferred action can be granted on others in different categories and for different reasons. So is an act of prosecutorial discretion that defers proceedings to remove a non-citizen from the U.S. for a certain period. Deferred action does not provide lawful status, but it does allow those with deferred action to obtain employment authorization. So as I mentioned previously, a recent change in policy from USCIS, I believe since 2022, USCIS has been granting deferred action to anybody to people who have been granted SIJS after filing the form I-360. Okay, so with their form I-360, it says you've been granted special immigrant juvenile status, and we've also been granting you deferred action. And that deferred action grants them also work authorization. So they do have to apply for that work permit separately. Some people have attempted filing the I-360 and the work permit application together. kind of being like, if you're going to file this, approve this form, might as well apply for the work permit. We've seen mixed results. So what we usually do at NIJC is that we'll file the I-360. If it's approved, then file for the I-765. And the turnaround right now has been about a month, which is great. And that work permit is valid for 4 years. This is essential because, as I briefly mentioned in the timeline, it can take up to 5 years before they can then adjust status. And so before 2022, we had a lot of kids who, you know, if they applied when they were 20 and they're not eligible to adjust until they're 25, you know, a lot of them are starting their lives, starting families, trying to work, trying to go to college. And so without employment authorization, it made things very, very difficult. And it was kind of very hard to explain. You have a form of status, but I can't really give you a lot of, you're still not eligible for some certain types of benefits yet, and benefits as in like work permit authorization, for example. And so this change in 2022 was much appreciated and has been very beneficial to a lot of our clients. Deferred action, it can also be a basis for terminating removal or deportation proceedings. So if you have a client who is in removal proceedings, you can cite to the grant of deferred action as a reason why they should terminate proceedings against the minor. In Illinois, specifically the Chicago Immigration Court, Immigration Judge Payton has been very much pushing for this, and we've been able to get a lot of our kids out of proceedings based on a grant of SIJS deferred action. Okay. So the visa bulletin. So as I mentioned, after a person is granted Special Immigrant Juvenile Status, once their I-360 is approved, they cannot automatically adjust status. So when this category was enacted, you know, there was no wait. And so people could adjust status as soon as their I-360 was approved, right? But there has now been a backlog of applications, and there's only a certain number of visas available every year under this category. So if you were to look at the visa bulletin on the State Department's website, for example, for September, you'll see that SIJS falls under the 4th category, and currently they're processing applications from January of 2021. So we're currently in September 2024, so you would think it'd be about 3 years wait, but sometimes the visa bulletin moves, sometimes it doesn't. There was a period in the past few months ago where it stayed for 3 months on one date, on 1 month, one date. And so things weren't moving. And then there have been times where there was a significant bump of like 3 months at a time. But we like to say that it's a wait about 4 to 5 years, just to kind of set expectations with their clients, as well as, you know, we never know how things are going to change. So if you're ever trying to look that up, you just Google the visa bulletin for the month that you're in, and it should link you to the State Department, and you'll look to the final action date, and you'll go to the 4th category, and you'll see that across the board, every country has the same priority date. All right.
Dominique, if I can hop in about the visa bulletin, the unfortunate thing at this point is the other factor that you need to look at in order to calculate about how long a wait will be. USCIS also publishes data about how many applications are pending, because there are only a certain number of visas that are released that become available every year. And so I believe we are at, I may be saying this wrong, I think it's 7,000 visas every year, and there's at least 100 and something petitions that are pending. And so if you calculate that separate and apart from what year they are processing applications, we are looking at more than a dozen years wait. This is a relatively recent phenomenon, and I apologize ahead of time if I've said the number of visas wrong. I think I may have. The calculations that we're doing makes it appear that there is going to be at least a dozen years wait. But what I want to plug is that there are folks who are doing really fantastic advocacy to end this backlog altogether. I encourage everyone to look up the End SIJS Backlog Coalition, because a dozen years wait for a green card does not make any sense for this vulnerable group of kids. There are lots of reasons that their access to visas should not be placed in the employment-based category of the visa bulletin. It is a humanitarian form of relief that should have its own separate set of visas, and they should not have to share with these employment-based categories. So really, the NSIJS backlog is doing great work. They have made some strides in terms of advocacy. But if this is an issue that you are interested in, or you know folks impacted, please look them up, because it will become a more acute problem the more applications are submitted.
All right, thank you, Hillary. So that's it for my section. I will now be monitoring the chat. I know that there's some really, really great questions in the Q&A, I should say. Some of them will be addressed in the slides upcoming, and then some of them I think we're just going to answer the Q&A because they are very, very specific. But please know we are monitoring them, and if necessary, I will interrupt Hillary to ask a question that needs to be that would be helpful for everybody to hear. Okay,
there's a couple, Dom, that I think are appropriate to answer at this point, because
sure.
there's I see a lot of immigration lawyers in the chat, because I'm seeing a lot of good like SIJS as opposed to state court based questions.
Sure.
So I want to skip the one about the divorce decrees, because I'm going to address that in my section. But there have been a couple of questions about the effect that a grant of SIJS can have on their parents' ability to obtain status. Can you speak to that a little bit, Dominique?
Yes, I will. So the question for everybody is, would a child getting SIJS affect either parent's ability to obtain LPR status through another method that is not the child petitioning for them? So I will speak to both sides. So if it's a parent who is non-abusive and they just can't apply through that child, that specific child that was granted SIJS, and they're applying, say, for a family petition or asylum, and then they are now ready to adjust status, it should have no effect on their case at all. We have a number of cases where we were able to apply, or somebody else on our team at NIJC is able to apply for the parent through another means, another category that they're eligible for, and it shouldn't even come up really, because it's not anything against them. Now, for the parent that was abusive, I don't believe that there is anything in the regs or anything like that that would be against that parent applying for any other form of relief. Although I will note that if it's based on how, Hillary, would you, I mean, it's discretionary, I would say, but it's not anything that should affect them on any type of form of application.
Yeah, there's a question in the chat about that specifically. What impact does an SIJS petition have on the parent's ability to obtain status? Can adjudicators determine that a parent lacks good moral character based on their child's claim in their SIJS petition? And SIJS petitions are supposed to be protected in the same way that, for example, VAWA or U visa petitions are protected. We probably can't guarantee that USCIS would or would not communicate in any particular way. And I think I would also point out that the family court proceedings are often public record, depending on the court that you go through. So we can't promise that there's going to be no records if DHS really wants to find something against your client. But the intent is not for this to affect even the abusive parent's application for status.
Great. Thank you, Hillary.
And I think there was one more question related to this, which was about U visas. I'm not seeing it in the question and answer, but it might have been in the chat. But I do want to clarify the piece that Dominique was saying, where the statute says that a parent can never benefit from their relationship to the child. The language used is under this chapter, which refers to the entire INA. So if, as Dominique said, if the parent applies for asylum, or if some other family member petitions for the parent, either the abusive or the non-abusive parent, that's fine. But for something that requires the parent to benefit from their relationship to the child, such as, for example, being derivative on a U visa, that is not going to be permitted under the chapter. We haven't tested this theory recently, and I think it's a little bit hard because U visas are so very backlogged. But the experts that we've consulted with are pretty clear that the INA, that the language is pretty clear that it applies to the entire INA. So in terms of protecting your clients, you really want to make sure everybody's fully informed about the fact that a child petitioning for SIJS means Parent can never get derivative use status, parent can never get family petition, and if there's any other benefit that it depends on the parent's relationship to the child, that will not be able to happen.
Okay. Okay, I do believe the rest of the questions are more applicable to the second section or would be better answered in the Q&A. So I will go ahead and pass this over to Hillary to talk about the state court process.
Sounds good. Can we move to our next slide? So I'm going to talk a little bit about getting a predicate order for SIJS in Illinois. As Dom mentioned, this general process may be applicable in other states, but each state's law is different and each state has different types of court systems. So even more specifically, what I will be talking about today is how to get an SIJS predicate order in family court or in guardianship court. As you saw at the beginning, you can also get SIJS predicate orders, those custody orders with the special findings in DCFS proceedings, so child protection proceedings, in juvenile delinquency proceedings, because often if a kid is in delinquency proceedings, it may be a result of some abuse and neglect on the part of a parent, and in adoption proceedings. But the juvenile court proceedings, so delinquency and child welfare, those are not private petitions, meaning if you want to get a predicate order out of that, you will need to communicate with the state's attorney who files those petitions. And adoption proceedings are their own special separate proceedings, so we're not going to address those today. So today we're going to talk about custody and guardianship. So we have our little roadmap here. The first step is always going to be to review your case file and meet with your client and make sure that they're fully informed about the process and are agreeing to all of your steps. You will draft and file your petition depending on the type of case. And then you will need to either provide service of process to or notice to the appropriate respondents in the case. And we'll talk about who those are in the next section. Once service has been completed or notice has been completed, you'll be able to schedule your final hearing at which you'll prepare the client to testify. Your client in this case, and we'll talk about this as well, is the petitioning parent or proposed guardian. In Illinois, in these types of proceedings, the child is not petitioning for themselves in state court. This is the adult. And then at your final hearing, hopefully, if everything goes well, the judge will enter your order with the SIJS findings, and you can move on to the immigration law step. So, as I mentioned, your client's the petitioning parent or guardian. This is one of those scenarios where you want to think about ahead of time and really manage expectations with the family about who the client is and what could happen if any conflicts came up. This may be different depending on whether it's a parent or whether it's a proposed guardian and the age of the child. You will need information from the child, and the child is the one who's going to be benefiting from this petition, but you have now built an attorney-client relationship with all of the duties that apply with both the parent and eventually the child. You want to review all of your information before you file anything in court. I don't know how many times I feel like we've spoken with folks who have drafted their petition based on certain assumptions, didn't fully review it with the client, and then filed it in court. And in fact, some of that information has changed or is incorrect. Please make sure that you're speaking with your client and involving your client in the process, as well as using an interpreter where possible. This is not a situation where you want to muddle through with like nobody fully being fluent in the other person's language. And then finally, you want to discuss risks with family members before filing in state court. The conversation that we just had about parents never being able to benefit from their relationship to the child in terms of immigration benefits, that has to be discussed before filing. Another question that we frequently get is about immigration enforcement. Fortunately, in Illinois, we have not seen any ICE enforcement for folks appearing in state court for family law cases. That could change if we had a different administration, but we do need to advise our potential clients, especially if they're undocumented or if they have an outstanding removal order, of the general risks of existing in the United States without status. But like I said, appearing in court, often in Zoom court, thus far, we have not seen immigration enforcement actions as a result of that. All right, so what kind of case are you going to file? Generally, we divide these into two types, parent and non-parent. But going back a step, the SIJS predicate order, according to the INA, can be obtained as a result of a case that involves a finding of custody or dependency. That's what the statute says, and that's a reference to the fact that state laws are different and have different types of proceedings. The court doesn't have to make a separate finding of dependent on the court if they're already entering a custody or guardianship order. This is either or. So in Illinois, we have custody proceedings. We don't really have dependency proceedings as a separate type of petition. In Illinois, our dependency findings are used as part of the child welfare proceedings as sort of an alternative to abuse or neglect, but there's no separate dependency proceeding that meets the custody prong. What that means is that if you were filing a private petition on behalf of a parent or a guardian, you will either be filing custody, which means a parent is seeking a legal order of custody over their own child, most likely, or a guardianship, which usually means a non-parent is seeking this order and guardianship counts as custody. But may also for post-18 cases, so kids who are age 18 to 21, even if they're living with a parent, that parent has to seek guardianship. That's just the way that the law is written. Let's move to our next slide. Filing and fees. So NIJC is a civil legal service provider, meaning we serve specifically low-income folks. And so the reason that we talk about this is if you are filing a private petition in state court, there is a fee to file either a custody or a guardianship case. If you are a legal service provider, so NIJC, Legal Aid Chicago, I see a couple folks from like North Suburban Legal Aid on here, you should be able to automatically get a fee waiver for your client using the civil legal service provider fee waiver. Basically, the state says we've already determined that our clients are low income, so we don't need to go through the separate fee waiver process. If you're a private attorney filing for a client, they will either need to pay the fee or they will need to file an actual request for a fee waiver, and a judge will need to assess whether based on their income or their other financial hardship, they would be willing to waive that fee. All right, so first up, we are going to talk about guardianship cases. Typically, they're filed by a non-parent. Guardianship is something that essentially allows a non-parent to step into the shoes of a parent. With the exception that I mentioned, in Illinois, the section of law that allows us to seek these SIJS orders for 18 to 21-year-olds is via the Guardianship Act. So in that sole circumstance, a parent would be seeking guardianship of their own child. Guardianship cases are under the Illinois Probate Act, so you would be going to probate court for this specific case. And a guardianship meets the custody requirement. So even though it's called guardianship, you're still placing the child under the custody of the petitioner. Like I mentioned before, if you have a guardianship or a custody order, you don't need a separate line that says this court finds that the child is dependent on the court. That is assumed as part of the guardianship or custody order. All right, so in a guardianship case, parental rights are not terminated. This is really important to know as you are working with your client to assess their relationship with their parents, to assess whether, whether a parent may agree or consent to the proceedings. This doesn't completely sever the parent-child relationship. And if a parent wanted to come and discharge a guardianship, a court-ordered guardianship, they could relatively easily do so. The difference in SIJS cases is that quite often the parents in our cases are in another country. That would make things much more difficult. In a standard guardianship case where you're not seeking SIJS, it's simply that a parent is not available to provide that care. The parent would be required to show up in court and establish that they are in fact available and capable of providing that daily care to the child. And then once they prove that, it's relatively easy to discharge a guardianship and the child goes back to the parent. But like I said, SIJS cases usually involve someone in another country, or at least someone who is not planning to come back to court and contest the case. If you have a contested case where a parent is trying to get custody back of a child, you probably don't have an SIJS case, because even if a parent can establish that that the other parent should not have sole custody of the child, very unlikely that a judge will enter an order specifically saying that the child can't be reunified with that parent if that parent is actually seeking visits or custody. Like I said, in Illinois, guardianship cases are heard in probate court. In Cook County, there's a separate probate court and a separate judge that hears the minor guardianship cases. In other counties, where the courts are smaller, the judges have general jurisdiction to operate under various acts. And so custody and guardianship cases might be heard in the same courtroom. All right, so who can be a guardian? You must be, per the Probate Act, per the statute, at least 18 years old, or if you're petitioning for a post-18 kid, you must be at least 21 years old. A resident of the United States. We have a little star here because in the past, this was interpreted by some judges to mean a lawful permanent resident or a citizen of the United States. That's not what the statute says, and it's not what's required. It simply is intended to establish venue and residency for the purpose of the petition. So if you live here in the United States, you can be a guardian. The next two factors of sound mind and not adjudicated disabled by a court simply mean if you are under a guardianship due to your own disability or mental health, you will not be able to be a guardian of someone else. And then finally, not convicted of a felony. There are some circumstances where if someone has a very old felony that doesn't involve harm to a child, the court could consider it and appoint that person a guardian. But if the felony involves harm to a child, that person's not getting guardianship. So this is the screening you will need to do of your proposed guardian. All right, so documents for guardianship cases. Keep these in mind because this can be tricky, especially if you're working with perhaps an immigrant who may have lost documents or may not have been able to obtain documents. You will need the minor child's birth certificate to establish their identity. If a parent has died, ideally you want that death certificate. If you don't have a death certificate, depending on your judge, you may simply have to proceed via publication as if the parent were alive and simply MIA. And then you will need a photo ID for the proposed guardian. This can be a passport from another country. It can be a work permit. Folks have used city keys if they live in Chicago, a driver's license, but they will need some sort of identification. Typically, the child must be in the guardian's physical custody. That means that they are living with the guardian is taking care of them. But I believe we're going to talk about this on our next slide. There are some situations where if a child is older or a child is placed in some other sort of residential living situation with the consent of the guardian, and the guardian is simply acting as, let's say, a mentor, someone who's providing guidance to the child, that is contemplated within the act, and we have seen judges grant guardianships in those scenarios. All right, so drafting and filing your pleadings for guardianship, you want to make sure that you're going to use a standard guardianship petition, right? NIJC has samples on our website. There are also, most counties have form petitions because this is often something that folks do by themselves. Pro se litigants often file for guardianship just because of the nature of the type of case. But you will want to make sure that in your petition, you are making allegations so that you can get this SIJS magic language in your final order. Specifically, you want to allege that the child's reunification with their parent or with their parents is not viable. You want to make sure to name the parent so we know who we're talking about, due to either abuse or abandonment or neglect based on those definitions that Dominique reviewed earlier, and that it would not be in the child's best interest to return to their home country. That can either be because there's no appropriate caretaker there, because the child fled due to danger, but you want to have just the bare minimum to establish that this language is required in your final order. As Deepak mentioned earlier in his section, We don't want to do an entire affidavit's worth of information here. We really want to keep it to the bare minimum. And then if the judge wants to hear more details, he or she can ask about that at hearing. But these are sensitive documents. They are documents that someone could go to court and obtain later. And so usually I try not to put the child's whole history of abuse and conflict into these pleadings. All right, so providing notice. Guardianship cases under the Probate Act do not require the same formal service of process as custody and other types of cases, but you are required to provide notice, and typically that is via return receipt mail, relatively simple. But you are required to provide that to both parents and adult siblings. Those are the people who would, in theory, in a guardianship case, have essentially a right of first refusal. Ideally, the court would want to place a child with a parent or with an adult sibling as their guardian, if at all possible, meaning those folks have to be notified of the case. You can, as I mentioned, provide return receipt mail, but often we don't know where those people are, or we don't have a functional address for them. We have a lot of clients who live, for example, in rural areas in other countries, where there's simply not an option to FedEx a notice and get a return receipt. In those scenarios also, even if we know like they are in this rural area on this one long road, we're going to proceed via publication, and we're going to establish to the judge, sir, notice isn't feasible in this scenario. Two other options though are if a parent is willing to agree, and I think this was in one of our questions in the Q&A, if the parent's willing to agree to the entry of guardianship, they can sign a notice of appearance and consent, and we can file that with the court instead of the return receipt mail. However, that signature must be notarized. And the immigration attorneys on the chat may know that in a lot of countries, getting something notarized is very difficult and very expensive. So in many cases, even if the parent is aware of what's going on and agrees, we will still proceed via publication, and that's been what's considered appropriate by the judges. And then finally, if a parent is deceased, we can file the death certificate instead of notice. That will need to be translated. If we don't have a death certificate, we're going back to that publication for notice. Oh, one last thing I want to mention about notice. Often our clients have siblings they know about, but often they may say to us, the child may say to us, well, I have a bunch of half siblings on my dad's side. I don't know who they are, or mom's side or whoever. Half siblings are entitled to notice under the act. We have in the past, I think, provided notice only to full siblings. I think we've clarified now, especially with the input of CVLS, we do need to name and notify half siblings as well. If we don't even have a name, that's fine. We don't need to put them. But anyone for whom we have a full name, we either publish notice or we do need to send that full notification to them. All right, so background checks. This is a Cook County specific procedure. One of the many things in Cook County that makes things like just a little bit more difficult, but there's reasons for it. So all adults in the home must undergo 2 background checks. That means that can be tricky, right? Because if there's some other neighbor or cousin or Theo or somebody who's living with the family, they have to agree to this background check, and they can kind of taint the whole process if they're not willing to undergo it. So it's something to talk about with your clients before filing your guardianship petition. The child abuse and neglect tracking system is simply a name check. So you put your name and date of birth, and they run your background check to see if you have any hits with DCFS. The criminal background check is fingerprints. You can either do this via a private vendor, so go pay to get your fingerprints taken. But in Cook County, it's pretty easy to get the cost waived. And then you would go to the Daily Center. All adults in the home would go to the Daily Center and get their fingerprints taken by the sheriff for free. All right, so once you've filed your petition, you've provided notice, the time has run, meaning 30 days has run and nobody has objected to this petition, you will be, and you've done your background check, you'll be preparing for the final hearing. So when preparing for the final hearing, you want to make sure that you've requested an interpreter. The courts are required to provide interpreters. You don't have to bring your own interpreter, but you do want to make sure you let the court know, usually via email to the clerk well ahead of time, especially if it's a language other than Spanish. Typically, Spanish is there, easy to access, but they need some notice to provide an interpreter. You will also email courtesy copies to the judge, meaning a copy of your as-filed pleadings and a copy of your proposed order, which includes the SIJS findings. The probate court doesn't provide court reporters, at least in Cook County. Usually you shouldn't need one. If for some reason you feel like you want to have a transcript of this hearing for subsequent immigration purposes, you can bring one, but you would need to pay for a court reporter in that case. All right, so across the state, court hearings are held via Zoom. You will typically, Zoom is either an option or is the default. You'll check with your individual court. In Cook County, the default is Zoom. And so if you wanted an in-person hearing, you would specifically have to request that and explain why. If you are in a county besides Cook County, you might check your your court clerk's website to just see and make sure that Zoom is the default, but it is in a bunch of counties at this point. But that means you do want to make sure that you and your client are familiar with the Zoom platform, and CVLS has a great Zoom training. This one is from back in 2020, but they may have more updated ones. You want to make sure your client is prepared, right? I can't tell you how many clients have thought like they're going to be going on the hearing and telling their whole life story. For the most part, that's not what happens. The judge asks a few questions of you as the attorney to make sure that everything has been properly filed and noticed up, and ask the client just the very bare minimum of questions to make sure that they are eligible to be a guardian. Are you over 18? Have you been convicted of a felony? Do you live in the United States? And are you of sound mind and have not been adjudged disabled? They then may ask questions of the child if they're old enough to be questioned. You know, are you in school? Do you want this person to be your guardian? But it's pretty minimal. The judges do not go into questions of the child, at least, about the abuse, abandonment, or neglect. In some counties, some judges are a little more interested in establishing that factual basis and will ask the petitioner about any knowledge they have of abuse or neglect by the parent. But typically, the judges are able to rest on the pleadings that you've provided. I think one last thing, the Cook County judges, and increasingly in Kane County, in DuPage, in Lake County, the judges are pretty familiar with SIJS. And so once you flag that that's what's happening in this case, they know what's happening here. But you may encounter a judge who's not familiar with SIJS and may ask you, why are you here asking for like immigration findings? NIJC has extensive memos that are intended to be filed and also to help you explain SIJS to the judge and explain why these are not immigration findings. They're simply findings about the best interest of the child that will then use for immigration purposes. But state court judges do not have the authority to say yes or no to immigration status, and that's not what they're being asked here. They're simply being asked to do what they do every day, which is determine what is the best interest for this child in front of you right now.
Hillary, I think right now would be a great opportunity to highlight that judges, if they're required to enter SIJS findings if they are present.
That's right. So we do recommend that you read the SIJS section, either in the Probate Act, if that's your case, or in the Marriage and Dissolution of Marriage Act, if it's a custody case, because that language says the court shall enter the findings if supported by the evidence. So yeah, the judges are required to enter these findings. And if you do have trouble and you believe you've put on enough evidence for these to be entered, it's definitely worth an appeal. We've only had to appeal, I think, twice. But we won because the statute is so clear in this scenario. I'm also just looking over quickly about in these Q&As. I'm just going to go back through a couple of them quickly since we're at the end of the guardianship section. So it is Judge Dickler now in guardianship hearings in Cook County. It is not Grace Dickler, the former presiding judge of domestic relations. It's her daughter, I believe her daughter, Jamie Dickler. Judge Alonso has been moved. So Cook County Probate Court, currently Judge Dickler. I see a question about, is it sufficient if the child's birth certificate states the mother died during childbirth? Sufficient to establish that the parent is deceased. It might be, you could try that, but ideally we would have a death certificate. I see, why would it not be able to go into family court to get sole allocation instead of guardianship for an 18 or older child? So this is a really good question. In Illinois, the age of majority is 18. And so a parent can't seek custody over a child who is over 18 because that person is considered an adult. But in 2021, we worked with the Illinois State Legislature to provide a vehicle for 18 to 21-year-olds to be able to fully put into effect their rights under federal law, right? Because under federal law, a child age 18 to 21 can still be eligible to SIJS for SIJS. But if they don't have a way to get into state court in the state, then they are being treated differently than children in other states who may have that right. And so the way that the Illinois State Legislature chose to create this vehicle for kids to access specifically SIJS findings was through the Probate Act. It's simply for SIJS purposes. The parent has to go to guardianship court and get a guardianship over their own child who is age 18 to 21. That's just the way the law is written. And then I want to go up a little bit more. Should a predicate order entered by a family judge cite to the specific Illinois SIJS statutory provisions? Yes. So we are going to go into now what the language has to be. Or actually, we're going to talk about post-18 guardianship. But yes, we have samples. We do want to make sure that the final order not only includes that SIJS language, but cites to the specific state law definitions that support those findings. So briefly talking about post-18 guardianships, as I mentioned, these can involve either a parent or a non-parent. If it's a parent, that's just how the law is written. This is the vehicle to get those findings. So a minor includes an unmarried person under 21 who consents to the appointment of a guardian. But this section of law also means that a guardianship that was already entered can be continued after 18 if necessary to get these findings. So what that means is the petitioner has to be over 21. Other than that, for the most part, the same forms and process apply. You do want to make sure that you're citing the court's jurisdiction under state law to enter these findings for an under 21-year-old. Showing that they're still a minor, because this is a different thing than an adult guardianship. If the court enters an adult guardianship, that is for adults with disabilities of any age, and that will not be sufficient under the INA because the INA requires that these findings be entered by a court of juvenile jurisdiction. So we do want to cite to this specific post-18 statute. And we do have samples of memos of law. We have samples of all of the petitions. If you need an appeal sample, I see this in the chat, please reach out to us. I think we would have to go back and look at our appeals and like redact them and find out what was appropriate. But we don't have a standard appeal sample because we just haven't had to appeal that many cases recently. All right. Emily, can you tell me how I'm doing on timing? Let's see, it's 10:10 and we got to go through custody and APR cases. Let's see. All right, so custody in Illinois is actually called allocation of parental responsibilities. It's easier to say custody, but your form itself is going to be called allocation of parental responsibilities. It is almost always filed by a parent. There's a provision for a non-parent to file. That's not really applicable to SIJS cases at this point because we are able to go via guardianship for non-parents. Custody determines the physical residence of a child, so who gets the child to live with them, as well as who gets to make legal decisions, who gets visits. And this can be filed alone or as part of a divorce if the parties are married. Typically, we will file only the custody petition simply because we're not family law attorneys. We don't really want to touch a divorce because there are other implications for that, like property, like maintenance. It's just not something we typically do. Let's go to our next slide. Oh, look, here's our first CLE word. Please write this down. The word is predicate, P-R-E-D-I-C-A-T-E for those on the phone. Predicate. All right, did everyone have time to write that down? We're going to move on. All right, briefly talking about what kind of case do I file. Like I mentioned, for SIJS cases, the preferred petition is for allocation of parental responsibilities. That's simply because we're immigration lawyers. It's not really our job to do divorces or legal separation. But if you're aware of someone who is already in that process and their child may be SIJS eligible, it is worth looking into and perhaps speaking to their family law attorney about getting SIJS for the child as part of that dissolution or legal separation. All right, if parents are unmarried, you will then need to consider whether parentage has been established. So if parents are married in Illinois and the child was born of the marriage, there's a presumption that dad is dad and mom is mom. If the parents were not married, then you, at the time of the child's birth, then you want to look at the child's birth certificate. This is usually what's going to tell you if parentage has been established. That's not always the case in family law cases in Illinois, so please take this as advice pretty much for SIJS cases only, because there are other steps to establish parentage. But typically for our clients, if we look at a child's birth certificate from Honduras or from wherever and dad's name is on that birth certificate, for USCIS purposes, parentage has been established. But if there is no father's name on the birth certificate, or very, very rarely if there's no mother's name on the birth certificate, then you will need to include a request to establish parentage in your petition. And then that will be included as part of the custody matter. And then non-parents, we're going to skip over non-parents because really our recommendation for SIJS cases is that non-parents file a guardianship case. But if you have other questions about that, you can feel free to reach out. So again, your petition for sole allocation of parental responsibilities, otherwise known as custody, should look like standard family court pleadings, right? We have samples on our website. I believe the county courts have forms that can be used for pro se litigants, but they should, in addition to the standard pleadings, allege facts sufficient to support those findings of abuse, neglect, or abandonment, and facts sufficient to support not in child's best interest to return to home country. And you'll include a request for those specific SIJS findings. As I mentioned already, we want to do the bare minimum to get the findings. And I think also best practice is to avoid any mention of the parent or sponsor's involvement in the child's journey to the U.S. We see a lot of kids who come here to reunify with parents who are already here. And this practice evolved as a result of a practice during the Trump administration of accusing parents of smuggling or trafficking their own children. So it's not really the state court's business how the child got here if right now they are safe and it is in their best interest to remain here. So we really try to avoid any talk about the parent themselves, their immigration status, or the child's journey to the United States. It's simply not relevant. All right, again, the magic language, these are the absolutely necessary findings that should be in your final order, and the request should be in your pleading. The child's reunification with one or both parents is not viable due to abuse, neglect, or abandonment, or a similar basis to one of those under state law. And this must include a citation to the state law definition, which in the IMDMA is in a whole specific section, and in the Probate Act, it's in its own SIJS section. And then finally, that it would not be in the child's best interest to return to their home country. All right, so for example, because we've been talking about keeping the bare minimum of facts sufficient to support the allegations, here's some sample language that includes the citation, the definition, and just like the minimum facts. The respondent neglected the minor children by failing to perform caretaking functions pursuant to this section. They failed to provide food, shelter, support for 8 years, had no relationship with the minor since she was 3 years old, etc. So 1 to 2 sentences max. And then finally, establishing paternity. So these may be trickier depending on your judge and your scenario, but USCIS has a policy that they want to see that the court has established paternity as part of the SIJS predicate order. There are scenarios where the court is not going to be able to establish paternity or refuse to do so, and if so, you can take it up with USCIS. It's not a hard and fast rule, but they will want to see an explanation. So in general, I would prefer to try to get this done in state court where I can see and speak to the person making the decision. than sending something off to USCIS. All right, and I already talked about this. So if parents are married, there's a presumption of parentage. Otherwise, we need to seek a paternity finding. These factors, including a voluntary acknowledgement of paternity, that can be helpful, right? If you have a father who's willing to sign off specifically that acknowledging that he is the father of the child, that's great. Then you don't have to separately seek a finding of parentage from the court just based on your pleadings. You can seek a finding of the court based on his voluntary acknowledgement. All right, so e-filing, this can be tricky. If you are a law firm that has a docketing service, hopefully it's not, because you can send this off to them to do. Otherwise, you will be e-filing through whatever e-filing service in the Illinois state courts you have. Typically, you want to make sure your petition is filed along with your cover sheet. So usually whatever court you're in will have a county-specific cover sheet. That should be in one PDF. And then your CLSP form, which is your fee waiver, that should be included in your initial filing. And then if possible, your affidavit of military service. So the list of these documents is included in our checklist and on our website. It's also available on the court's website. But the affidavit of military service is simply because for folks in the military, there are certain protections that they're entitled to when their spouse may file for divorce or for custody. So typically in these cases, our client signs an affidavit saying, no, the child's father has never been part of the U.S. military and in fact has never left whatever their home country is. So that's your initial filing. And then when you get your documents back and when you are ready to proceed with the case, you will file your, for example, motion for service by publication if you will be proceeding on publication, or service by whatever method is appropriate in your case. All right, so in custody cases, service of process is required. It's a little bit more stringent than the notice requirement of a guardianship case, which is simply mailing and establishing that no one has responded. Service of process are the specific procedures that are intended to give actual notice or also constructive notice to the other party in the case. If your respondent parents have signed a consent and waiver, we talked about getting those signed and then notarized. You can file those and then you can ask to proceed via consent. Otherwise, you have to determine how you are going to serve the other party because that is how you're going to move your case forward. All right, so the most common service options in a standard case where you're filing for custody that is actually contested is by sheriff. So if the other party is here in Illinois, you file your petition, you place your summons with the sheriff, and the sheriff is expected to go out and serve the person or by some other individual appointed by the court. As I mentioned, SIJS cases are typically default cases because if a parent is contesting custody, it is very unlikely that a judge is going to be able to find that the child's reunification with that parent is not viable. So most often we're looking at publication because we don't know where the other person is, or possibly consent and waiver if the other person has agreed. I will note that even an abusive or abandoning parent may be willing to sign a consent and waiver. Sometimes a parent is just willing to do this thing because they know it will benefit their kids. Sometimes they are just so thoroughly checked out that they don't care and they're like, go ahead without me, but it's worth looking into. All right, if the respondent is deceased, which is the case in a lot of our cases, you cannot serve or give them notice, but in a custody case, judges have allowed us and in fact required us to appoint a special representative for their estate. So instead of moving for publication, this is in a custody case only, right? In a guardianship case, we simply file the death certificate and then we are able to proceed. In a custody case, we'll file a motion to appoint a special representative and get an order appointing a special rep who will essentially receive service on behalf of the deceased party. Here where it says the special rep is usually an attorney we recommend. If there's a case like this that is an NIJC pro bono case, we will pull in CVLS here for sure because this is just slightly more procedurally complicated, but they do usually have volunteers that they can recommend as special representatives. Let's go to our next slide. All right, so when service is complete, meaning either someone has been personally served or publication has run for 30 days and no one has filed a response, then we can move to default the respondent parent. The final hearing is called a prove up. So if you're proceeding via service, it's after that 30 days has run. If you're proceeding via consent, the other person has consented, then you can move for an agreed prove up right away. So there are 2 hearings that are required. Particularly in Cook County, we've seen sometimes other judges in other counties are willing to do this in one, but essentially the finding that the respondent is in default is expected to be done in a separate hearing than the final prove-up hearing where the final order is entered. So once service has run, you move for default, you go before the judge will call the respondent's name. If the respondent does not appear and service is appropriate, then the judge will enter an order saying that person is found in default. And then you will be scheduled for, or you will need to request to schedule your final prove-up hearing. That's where your petitioner is going to testify and request that that final order be entered. As always, if your case is not in Cook County, because a lot of our specific procedures are specific to Cook County, you will probably need to call the clerk's office just to see what the standard is in terms of procedures. The law applies in all counties, but the way that hearings go forward can be different based on county and based on judge. All right, so the final order is one that you draft. You draft your proposed order and you submit it to the judge and ask that the judge enter it at that final hearing. Once again, we want to extensively review to make sure all of the magic language for SIJS is there. The child's reunification is not viable. This has to be exact. You can't say reunification is not possible. You can't say reunification is unlikely. Reunification is not happening at this time. USCIS is very literal, bless their hearts. Reunification is not viable. It has to say that. And then it will have to say due to abuse or abandonment or neglect, whatever is appropriate. And it must include a cite in an APR case to either the IMDMA or the Parentage Act, plus a brief description of the factual basis supporting that cite. And then it must say that it's not in the child's best interest to return to their home country, name the country, and say briefly why. That's our SIJS language. So finally, if you are a family law attorney or a pro bono attorney, make sure that the immigration attorney is reviewing these pleadings at the beginning and reviewing the final order at the end to make absolutely sure it's sufficient for USCIS before the order is entered. We have had to get orders amended before, and that is just more work for everybody. But USCIS, as I mentioned, is very literal and very strict about what they're willing to accept. So you really want to cross-check everything and make sure everything is absolutely correct by the time your final order is entered. All right. Just a couple of things about court hearings in Cook County because it's a little more complicated in domestic relations court. There is an individual calendar system and a team calendar system because this division is so big. So if you file your petition and you get a letter, that means you're on a team calendar system, and you may see a different judge for different hearings, whether it's a preliminary motion or a final hearing. And you will need to communicate with your individual judge's clerk about that. If you have a number on your calendar, that typically means you should see the same judge throughout the life of the hearing. And you can look on the county clerk of court's website to find out who that is. Typically in an SIJS case, there's about 3 court dates. One would be your motion for publication, because publication really is the most common form of service in these cases. Your motion for default will be heard and at its own court hearing, and then the final hearing. So it's more hearings typically than a guardianship case, in which usually that's all done in one hearing. But it can be done pretty quickly within only a few months if you move the case forward. It is really important to know that in family court, you can file a petition and do nothing and sit there, and that case will just sit there for months and months and months. So keep in mind that it will be your job to move these cases forward. All right, so preparing for your prove update. I see that I am out of time. Bere, am I cutting into the Q&A time, or is this supposed to be over?
We do have wiggle room here, so we can just run through the slides and then they can reach out to me directly for more Q&A, and I'll be sharing my information, and that way you can reach out to me directly and our team. But yeah, keep going. We're here. We're good here.
Yeah, our team will stay on after to do Q&A, but if people have to get off, that's what we.
Sounds good. So just super quickly, these are preparing for your final custody prove up. You'll want to file your motion to set your prove up, send all your courtesy copies to the judge ahead of time. There's a list of documents here, and we have a checklist on our website as well. For Cook County specifically, if you're outside of Cook County, you are going to be responsible for checking for what your judge needs. You want to make sure you've confirmed your request for the interpreter. You want to make sure that you've reviewed with your client the questions that you will be asking at the prove up. You don't want to, a standard rule of trial practice, right, is never ask a question for the first time in open court. You will have reviewed those questions with your client. You'll be doing a brief direct exam. It can be leading questions, but you will simply be asking the parent, the petitioner, to affirm who they are, where they live, that the allegations are true, to record those for the court. That proceeding will be recorded if it's by default, and you will be obtaining and filing a transcript of your proceedings after the final order is entered. All right, parenting classes. They are required in all domestic relations cases involving children in Cook County and sometimes out of Cook County. Often judges will waive this requirement because, as we've mentioned, these cases are default. The other parent isn't even around, but some do want to see that the parent has taken this class. It's called Children in Between Online. It can usually be, the fee can be waived, and it usually takes about 4 hours to complete. It's available in English and Spanish. So first check to see if it can be waived. If not, it's relatively easy for your client to be able to take it, but they will need to take it. All right, for your final prove-up hearing, as always, it's important to know the judge, check them for standing orders, and if it seems like your judge may not be familiar with SIJS, bring your memorandum of law and be prepared to explain SIJS. If you get a judge who's asking all kinds of maybe inappropriate questions about immigration status, that may be a judge who needs more education on the way that the law is written in Illinois, which focuses their jurisdiction specifically on the best interest of the child before them and requires them to enter the findings if supported by the evidence. We do have these samples in our website. All right, so you want to make sure that your client is ready to testify, that they know how to use Zoom. Like I said, you want to review your direct exam questions ahead of time. Children will not be allowed in a custody case in court. In a guardianship case for older kids, the judge may want to just see their face and ask them if the proceedings are okay with them, but young children, the court does not want to see them, so they should just go to school that day like normal. All right, our CLE word number 2 is order. Let's write that down. It is 10:30. I apologize for going over, but please write down your CLE word number 2, which is order. All right. So as Dominique mentioned at the beginning, getting this SIJS order is the beginning of a very long path, but it does put the child on the path to a green card, which is huge in terms of providing them with stability. So we really appreciate that there is so much interest in this process. Okay. So in the interest of time, because I took so long, if you are able to stick around, we can kind of go through some of these specific questions, and we will also, we will also circulate the slides and the information.
So our first question that we have in the Q&A is, how different is SIJS state by state? So this question actually should be broken down. So SIJS is the same in every state. So eligibility is the same in every state because it's a federal statute, right? So they have to be under 21, unmarried, and present in the US, and then have been abandoned, abused, or neglected by one or both their parents. Now, if they are able to get a predicate order in each state is dependent on state law. So each state has its own requirements for how somebody can file and then get a predicate order. We mainly work out of Illinois, but we have done some cases in Indiana and Wisconsin, and mainly it comes down to procedure. I will note that Indiana and Wisconsin do not provide post-18 predicate orders. So in Indiana and Wisconsin, to be able to get an order in state court, the minor has to be under 18 versus in Illinois, it's under 21. So in state law, definitions may be different, and then their eligibility to get a state court order may be different, but to be eligible for SIJS in any state, it's the same. Okay. This might be a question for you, Hillary. The next question is, if there's an order from a foreign country involving the child that is seeking SIJS, i.e. a divorce decree, parentage, or just child support, do you need to first do a petition to register the foreign judgment or order and then file your SIJS petition under the case once it has been domesticated?
Yes. So this is a really good question. What it means, it's really going to depend on your individual case. If you do have an order from a foreign country and you've established that this is the full and correct order, and it is an order that establishes custody of the children, then it is possible that you will need to register that foreign judgment here in order to comply with the requirements of the Uniform Child Custody and Jurisdiction Enforcement Act in order for a court to take jurisdiction over that same matter. What we often find is that we are not often able to confirm that we have the full court order. We often see, for example, divorce judgments that don't include a finding of custody. We see child support judgments that don't include a finding of custody, or we are simply not able to obtain all of those documents. And if those are the case, then we will simply file a new petition on our client's behalf, because we can't, it essentially would be a due process issue if a child was prevented from obtaining the relief that they're eligible for simply because the clients are not able to obtain those prior documents from a country where they may be really unavailable. If you do have a question about that situation, I definitely recommend reaching out to the experts at CVLS. When we do have foreign judgments, we definitely run them by our family law experts to see what the best path is.
Okay, thank you, Hillary. The next question is, what if the abuse was inflicted for someone other than a parent who was in custody of the child and parents are not there? Would that be considered abandonment? So I think we're conflating, well, so I guess if I'm understanding the question, it's if the abuser was somebody else, but it was on account of the parents not being present. So it could be negligence, right? Because it wasn't the parent who inflicted the harm, but maybe because of a lack of taking care or keeping an eye on the child, they were then abused. I think that is a valid argument. It would, if the person mentions abandonment, it would be abandonment if that parent also has no contact with the child, right? And then that child is also harmed because they were put in the care of somebody else. So it could be both. So it could be abandonment and neglect. But just because somebody else harms another child because the parent was at work, that doesn't mean abandonment. Abandonment is a stated period of time where they have no contact or no support for that child. And that, at least under Illinois law, that's what the two definitions would be. But in this case, the child would be eligible for at least neglect in this hypothetical. Okay. So the next question is, can the parent who is alleged to have abandoned the child agree to the finding by signing a consent to the guardianship or filing an appearance and answer in the family law matter, for example, by agreeing that they have abandoned, neglected the child? So I believe we've answered this question. Yes, a parent who is maybe in contact and maybe is regretful for their past, or, it's explained to them that this is their one way for the child, one way to maybe get protection, may have some interest in, this is the only good thing I do for this child and I will sign a consent and I no longer have to take care of this child or, whatever. We have seen instances of that, and that is a possibility. Okay. Hillary, I don't know if you maybe understand this question. It's like, can CSPA apply for SIJS?
Yes, so the Child Status Protection Act is a provision that will lock in protections for certain individuals who were still considered children at the time that they submitted their applications in various contexts. Catalina, you can tell me later if you have a more specific question, but generally what I would say to this is SIJS has its own protection. So you do have to submit your petition for SIJS before you turn 21. But if it is submitted before you turn 21, your age and your eligibility is locked in as of that date. Same with adjustment of status. You simply have to establish that you filed your viable SIJS petition before turning 21. And then as long as you meet all of the other requirements for adjustment based on SIJS, you should still be eligible. I hope this answered the question. If there are more specific questions about the CSPA, you can let us know.
Okay. Thank you. So the next question is, what would you recommend in a situation where the IJ denied motion to terminate removal proceedings with an SIJS grant?
So yeah, IJs have different standards around this. We'll circulate or put up on our website our template. I think especially given the new termination rule that just went into effect, I believe last month, as well as the guidance on children's cases from both EOIR and ICE that are specific to Chicago, I think we have a really strong argument that if a child has been granted SIJS, specifically deferred action, removal proceedings really should be terminated. However, the language in the rules and in that guidance is not mandatory, so you might do a motion to reconsider if this denial was done prior to the new termination rule. But happy to chat about that, Andrea, afterwards if you want to talk about the details. And then the next question is about step parents eligible for a family petition. I actually don't know the answer to that because we don't really do family law. Are step parents typically eligible for a family petition? And if so, I don't. That's a good question. I don't know the answer to that. I'll put that on our SIJS.
By like a adoption, like if they were adopted by a step parent, or
yeah, then they're a biological parent, and then the INA prohibition would apply. So this is a good question. I don't have the answer. We'll see what we can find out from some SIJS listservs.
So the next question is, can you talk about what happens when the proposed guardian and the minor live apart? Also, some judges require the minor to be enrolled in school. Are they legally allowed to do so? We could probably divide this up, Hillary. So the proposed guardian living with a minor. So there have been a few instances where, for example, the minor is 18, 19, and they're going off to college. And they're living in a dorm room or on campus, and they're not maybe even in the state, right? We go back to civil procedure and talk about domicile, right? If their permanent residency is with that guardian, we still allege that they are under the care and are living with that proposed guardian. So if that's the case, college is similar to going for summer camp or somewhere, right? Now, we also have instances where somebody who is in alternate housing or is staying at like a residential facility for a number of reasons, and a proposed guardian would like to petition for them, we have made the argument that it is in the best interest of that minor to remain in that transition housing or that housing option, and that has been agreed upon by the guardian and the minor. So I think it is case by case basis, but it very much, a lot of the judges, especially if the minor is under 18, require that the child actually physically reside with the proposed guardian. Okay, and then the requirement for the minor to be enrolled in school. So Hillary, I don't know if you want to take that one or if you want me to answer that one.
Yeah, I mean, kids are supposed to be enrolled in school. If you're a minor, you're supposed to be legally in school. If there's a specific reason that you can't be, I think that would be a case-specific scenario. But we do, when we assess our cases, talk to both the guardian and the minor child and let them know the judge is going to want to see that you're in school. And just because you're 16 or 17 and you've decided to drop out to work because you have to, like, we recognize that that's a scenario, but we really want to make sure that we're preparing the case as best as possible for the judge. And yes, minors are legally required to be attending school.
I will say
up until age 17, maybe 16.
Yes, Hillary just touched on that. I will say there's an exception if the child is over 18 and is a post-18 guardianship It's not the biggest deal if they're not enrolled in high school, community college, or college. But anybody under 18, it would be very imperative for them to be enrolled or to be going to school. Okay. The next question is, if a SIJS applicant is over 18 and has a guardian appointed for purposes of obtaining a predicate order, will they need to continue the guardianship until they turn 21? Is there an impact on their eligibility for SIJS if a guardianship terminates during while their application is pending? Yes. So, Hillary, you want to?
Sure. So our process has typically been, if the SIJS applicant's over 18, our standard scenario has been, the language we put in is that they're appointed guardian until the person is 21. But the language in the probate statute doesn't necessarily establish a new age of majority. It just gives a right to individuals age 18 to 21 to access this guardianship. So my position would be, if they chose to terminate the guardianship before 21, that wouldn't be equivalent to a termination of a custody order, at least for USCIS purposes. Additionally, USCIS guidance has changed in the last couple of years to clarify that termination of a juvenile court order, really the language that would be required for USCIS to consider revoking eligibility for SIJS would mean that the court has specifically reversed some of the findings. So the court has found the child eligible to reunify with their parents, or has revoked the finding that it wouldn't be in the child's best interest to return to their home country. So I think that it would be possible to terminate a post-18 guardianship prior to 21, and have a decent argument that it shouldn't affect the child's SIJS eligibility. But I do see another question here at the bottom about letters of office. So yes, you would need to comply with the state court's requirements in order to properly terminate that guardianship. And that includes so in a guardianship, the court issues letters of office, which are essentially the formal documents saying that a guardian is the guardian. And courts often require the guardian to report back yearly in order to show that the child is still, eligible for the guardianship, that no harm has come to the child, etc. So you would want to formally terminate your guardianship in court if that's the case.
So then our next question is, does a parent or guardian's ability to financially support the juvenile affect the SIJS application or predicate order? Thinking of a single parent who does not have substantial income, has 3 biological children, and is considering becoming guardian for 2 more children.
Yeah, if the parent is seeking guardianship of 2 children that are not their biological children, I think that's a really good question. Because the judge is going to want to see, and if you're in a jurisdiction where they appoint a GAL, they do want to see that individual can support the 2 children. It really depends, right? Some judges will simply look at our pleadings, see that they're default, and just enter them because they know that the law requires it if supported by the evidence. But this is actually a really good question that is substantive to the proposed guardian's ability to seek guardianship. That being said, our courts are not in the business. Let me rephrase that. Our courts should not be separating parents from children simply due to poverty. DCFS is not going out and probably, if you go to court, the judge is not going to say, okay, well, you're not able to support them, and therefore what? The children are out on the street, or DCFS comes to pick them up. It's unlikely, but you do want to prepare for those questions when you are preparing the case.
Thank you, Hillary. Is testimony sufficient when a death certificate is not available?
Depends on what for. If you're talking about service, and you're in Cook County, probably not. If you don't have a death certificate, then you're probably going to have to publish as to the parent who is allegedly deceased in order to satisfy the judge that the notice requirement has been fulfilled. If you're simply testifying that that parent has abandoned the child, then yes, testimony should be sufficient. You can have your client testify that the parent is deceased and has abandoned the child. And if the judge says, well, I don't have proof that they're deceased, then you can just say, well, also my testimony is that the parent has not had interaction with the child since X date.
If you have a signed and notarized consent, how do you request a hearing? Do you email someone at the court? How do you figure out who you need to contact? So I'm assuming this is in a custody or APR case and not a guardianship one. So you would file the notarized consent. There should be the drop-down menu should have the option for notarized consent. If not, you would file it as an exhibit. Then you would file a motion for default prove-up, and that is what triggers the calendar for that follow-up, for a default hearing, for a motion for a default. In that default hearing, you would explain that an appearance and consent has been granted, has been signed, and then would be given default. And then you would then do a motion for a default prove-up. So it's similar. You just have to file that. You just wouldn't have to wait for publication or service to run, essentially.
And how you figure out who to contact is its own special question. If it's in Chicago, please reach out to CVLS. If it's outside of Chicago, we are just going to send you to the phones and the internet. Like, it can be hard to get a hold of who you need to contact.
Does our client need to attend the default hearing? Normally, yes. I think some judges will, especially for the default hearing, it's going to just be the lawyers and the judge talking. But generally, yes, every time there's a hearing, unless the judge specifically says that they do not have to appear, your respondent should show up. But the child should never show up to any of these proceedings unless it's a guardianship hearing. And so that the child can verbally consent to the appointment of a guardian. What about CLE credit? I believe we mentioned this, but we are sending all of our links right after this hearing, including the surveys, the attendance sheet, the CLE credit, and also our links to our website and our templates and our all of our guides. So please, yes, we will send everything right after this. Same thing for non-attorneys who can get a certificate of attendance. We will give you a link, and that should trigger in a certificate of attendance. In a post-18 guardianship, does a minor have to continue living with the petitioner? So Hillary already touched on this. As we mentioned, if, say, example, the child is 18, we highly, highly recommend that they comply with the predicate order or the findings of the order until at least their Form I-360 has been approved. After that, if they would like to terminate the guardianship or to stop residing with that guardian, there's a process to do so, but we highly, highly recommend that they wait until the form is actually approved. And I don't think we actually mentioned this in the slides, Hillary, but usually the form right now is taking about 3 to 4 months to be approved. And it takes the proceedings to get a predicate order, at least in Cook County, is around 3 to 4 months. And so when framing it to your client, you should say, you should be expecting to live with your guardian for at least the next 6 months. Is that going to be an issue? Okay. So kind of, setting expectations for both the guardian and for the minor child about what is this relationship and how long it's going to be in the situation. Okay. And then how would you deal with a situation in which a client requests help with SIJS, and while the facts can be framed that a parent has abandoned them, i.e. they live in another country or not actively involved in caretaking, but may still have contact with the child? Good question. And this comes up actually pretty often. It depends on the situation, right? So if the parent is in constant contact, right, calls every day, every week, maybe financially cannot provide for them just because of the currency difference, right? From the US to whatever the currency in their home country, they can't actually feasibly provide for them. But they are in contact, they're checking in, they're asking how they're doing, they're having contact. I wouldn't consider that abandonment, right? And we wouldn't want to, say that for reasons of poverty, a child should not, is not in the care of their parent. If the parent only calls on Christmas and it's just like, hey, how are you? Okay, cool. See you I'll talk to you next year. We would consider that abandonment. So it is case by case, and I think it's up to you to look at the definition and see what that means. But yeah, if it's an occasional call where it's 2 minutes and that's it, and that's all they talk to them every 3 months, every 6 months, I would still consider that abandonment.
I think it's important for you to be comfortable as an attorney with the facts that you're putting before the court. whether there's a colorable basis for meeting that definition. And I think just also be aware of the court, right? In Cook County, usually, and even in a lot of the collar counties, because we are so used to this process, we often don't have the judges inquiring extensively into the factual basis, so long as we've alleged a sufficient basis in our pleadings. As Dominique mentions, NIJC takes the policy that we're not going to allege that mere poverty equals neglect or abandonment. That's simply a policy decision on our part. We do know that there are folks who get SIJS predicate orders simply based on the fact that a child is here and their parents are not. And that really kind of depends on like what the judge is willing to do, what the attorney is willing to allege before court, but it's a pretty fact-specific inquiry. And I think that, so Chi's question subsequently is similar. Is there a neglect argument when a child is forced by parents to drop out of school and work without pay? Like that's one that we would often, depending on all the other facts, but we would often say that that would be neglectful, potentially even abusive, depending on the conditions, even though those conditions are informed by poverty, right? So use your skills as an advocate, refer back to your ethics as an attorney. But a lot of these inquiries are pretty fact specific.
Yeah, so the question, in an under 18 guardianship, if a minor wants to leave the guardian's home and the I-360 has been approved, what problems involved with this? My concern is that the court will raise eyebrows that we're being shady, asking for guardianships that aren't truly needed.
I mean, I don't think that means that the guardianship isn't truly needed, right? Because a guardianship in general anticipates that a child is living with someone who's not their parent. And that inherently involves like some trauma to the child, which inherently is going to potentially give rise to some conflict. So if you have a teenager who's run away from the guardianship, like that happens just as often in a non-SIJS case as it does in an SIJS case. And so again, we're going to say like it's fact specific. Those guardians, especially of minors who are under 18, will have an obligation to report back to the court, and they can report honestly, or you can ask that the guardianship be terminated. But it really is going to be about those individual family dynamics. And I think you can be honest and explain to the court what's happening. If it's simply that the kid never wanted to live with this guardian in the first place, and now that their SIJS is approved, they're ready to bounce. We try to advise our kids, like we would really like for you to hang on because you are also still a minor child and you really need to be living with an adult if at all possible. But again, fact specific, skills as an advocate, be honest to the extent possible.
Good question. Are there agencies that help obtaining a guardian for those who do not have one? Okay, so this is a little tricky. I am hesitant to be, we don't want people who are say 17 and we're gonna then, find a guardian for them and then they are moving to somebody else's house that they do not know. I wanna be very careful about that. So we're hoping that it's always going to be somebody who is a relative, a family friend, somebody close and who knows this child and can also, a key point is that they have to testify as to why or how some parent abused or neglected them. So if this is a complete stranger, they may not know that. Now agencies, so if a child is in, for example, long-term foster care or is in transition housing, that's a different kind of discussion. It could be somebody that is working there that may want to take on this guardianship, but we've had a lot of pushback from these agencies and from these organizations not wanting to take on that liability. So question I think is, very hard to answer because there really isn't a network, for example, of guardians out there that are willing to take this on, especially because there's also a residency requirement, right? The child has to have lived with them for at least 90 days before the petition has even been filed. And so lots of potential yellow flags if we're, trying to find individuals who want to take these kids in. Yeah.
And Ines, you raise a question that's bigger, I think, than just immigration, than just like SIJS, right? Like DCFS exists because there are so many kids in Illinois who do not have a safe home, and DCFS doesn't have enough resources to take all of those kids and place them in appropriate foster homes. So, and we have a housing crisis. So there's kids who are unfortunately on the street and don't have shelter beds. Like that's a much bigger problem as far as, I think Dominique answered your question with respect to trying to find someone to act as a guardian for SIJS purposes though.
Yeah. Okay, and now we're just moving to the chat, but we're almost done with all the questions. So these have been really, really great questions. I really appreciate it. Can an older sibling be a guardian for an 18 to 21-year-old applicant? Yes. If the minor is under 18, so it's a minor guardianship, they just have to be over 18. If the child is over 18 and it's a post-18 guardianship, that sibling has to be over 21. Okay, so it's just basically they don't want two 18-year-olds taking care of each other. They want somebody who's a little bit more older, maybe a little bit more stabilized, to then petition for somebody younger than them. Okay, so that's essentially the only thing that I would consider when looking at an older sibling. But an older sibling is great, especially because they already have that familial bond. They presumably have contact and have relationship with the minor. Okay. Can we make a neglect argument when the child, for example, 14 years old, is asked by a parent to drop out of school? I believe we already answered that. And all payment goes to parents. Yep. Can the abandoning father abroad sign a consent waiver after the petition has been filed? Ooh, that's a little interesting. So I think
Yeah, they can, but it has to be notarized.
yes, but I'm also petition has been filed. Oh, got it. Sorry, I was assuming the I-360 petition, but they're talking about family court petition. Great. Okay. I was going to say, what was the basis for filing the I-360? Got it. And I think that's all the questions. So thank you. Thank you so much for everybody who submitted questions and for those that stuck around. I hope this is very helpful. Throughout while we were answering the questions, Berenice was passing along our information as well as the updated QR code for attendance. We will be sending our contact information and the QR codes again via email, so please look up for those. But in the meantime, if you have any questions or need to look up anything, please go to our website. We have an entire section on SIJS, predicate orders, guardianship, custody, and then the I-45 section as well. And then we hope to see you guys all again next in 2 weeks on the 25th. We'll be going over how to file the Form I-360 and the I-45 application once you have the actual predicate order. But
And
you guys
please take a case. Berenice will be circulating the predicate order case list. We have a number of kids in need of pro bono attorneys. So this is a good way to put into practice what you've learned today.
Thank you guys so much. Have a good rest of your day.